Chair recognizes the gentleman from Alabama, Mr. Backus, for 5 minutes.
Director Mueller, I also want to commend you on your service to our country. And let me ask you, I've been reading about the James Rosen case, the reports on it, and I find a great deal of confusion over what the Justice Department and the FBI have done and what they haven't done. You're familiar with the search warrant and the affidavit?
And that particular case?
Yes.
No, I'm not that familiar with it.
All right. Are you familiar? I mean, at the time the search warrant was issued, Stephen Kim had already been identified as the leaker of the information. Are you aware of that?
I'm not aware of the timing. I know this was 3 years ago.
Yeah.
So
No, actually in 2010, yeah, that's right. He had already been identified. I'll just tell you, if you read the affidavit, clearly he'd been identified as the leaker. And I know that Attorney General Holder said he didn't know of a prosecution, or wasn't a party to a prosecution of the press. And but if you read the search warrant, I know that it talks about Mr. Rosen as being perhaps an aider or abettor or co-conspirator. But if you read the affidavit, he clearly was encouraging Stephen Kim to leak classified information. I mean, there's quite a bit of that. In fact, he was concealing his identity and telling Kim to conceal his identity. Now, also according to this affidavit, and I take this as being true, I know nothing in this affidavit that has been disproved, this disclosure threatened our national security, clearly, and it probably or could have cost the life of our intelligence source in North Korea. Because I'm not even sure if the person is still alive. Now, just assuming that what I say is that assuming the affidavit's correct and that James Rosen was doing all this information, daily contact with Kim, I know that there's been accusations that the Privacy Protection Act was violated. But, it says that the protects journalists from being compelled to turn over to law enforcement any work product or documenting materials, including sources, before the information contained in these materials is disseminated. Now, it was disseminated a year before. So that I don't think is valid. It also prevents investigators from searching newsrooms to uncover information or sources that a news organization has assembled. I don't think that applies in this case. I know of no search of any newsroom or any work product. But it says there's no protection if there's probable cause to believe the person possessing the materials has committed or is committing a crime to which the materials relate to, including receipt, possession, or communication of classified material. Now, this affidavit contains 35 pages of very active recruiting of the State Department employee, advising him, the reporter, to use a fake email. And the search warrant was to Google. So there, it's been said that the government should take reasonable steps to obtain the information through alternative sources or means than the reporter. Well, I would think Google would be an alternative source. And there is a clear presumption, well, there isn't now, but there's a presumption, I think, against seizing reporters' work product. But I would ask you to read that affidavit. And my point is simply, from reading the affidavit, I would think it's clearly within the right of the government to prosecute this reporter.
I can tell you two things. One, I did briefly review the affidavit when the issue arose, so I am somewhat familiar with it. I can tell you that the focus of our investigations are on the person within the government has leaked the information.
Sure.
That is the focus of our investigations. And thirdly, I would say that given the issues that have been raised, that it's appropriate to go back and look at the statute that was applied to that search warrant and to the protocols that have been established in our exercise of our investigative ability when it comes to this tension between the First Amendment on the one hand and stopping leaks on the other hand.
Yeah,
Time of the gentleman.
Let
Time
me
of the
just say,
gentleman has expired.
Chairman, there was no prosecution.
Time of the gentleman has expired. The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman, and thanks to you, Mr. Director, for your years of service to our country. I remember so well seeing you right after 9/11. You'd been on the job just a handful of days, and you have certainly served our country well and honorably. And I thank you for that. I do have, following up Congressman Baucus's questions, I do have concerns about our posture relative to the press. And I wanted to talk about the issue of the phone numbers for the Associated Press or Associated Press reporters. It has, the Department of Justice recently let AP know that it had subpoenaed the records for 20 phone numbers as part of a leak investigation. And the AP has said that approximately 100 of its reporters use these phones on a regular basis. Now, one of the phones was the AP's primary number in the House of Representatives press gallery, and used by many reporters, not just the AP. And this raises concerns not only about the First Amendment, but also about separation of powers. Certainly, it is likely that many of the calls made by these phones were with congressional staff or members of Congress, and likely irrelevant to the leak case, but certainly do raise issues of speech and debate. I'm wondering, in the Department of Justice, the Attorney General has to personally sign off on subpoenas for reporters. In this case, since the Attorney General recused himself, the Deputy Attorney General apparently signed off. Who at the FBI needs to sign off on a subpoena request like this before it goes over to the Justice Department? Is that you?
No. It is at the assistant director level, if I'm not mistaken. I'd have to get back specifically to you, but I believe, depending on the context and what is ordered, it would be the assistant director in charge of the particular division that is doing that. And generally, it's the assistant director that handles the leak investigations.
In a case like this, would there be, at that level, consideration of the implications for chilling First Amendment rights? And would there also be an analysis of the speech and debate implications and the separation of power?
I think the flag would be raised on both of the, certainly it's a leak investigation. Any leak investigation, you know that you're in an environment where there are competing tensions. Anytime you come across anything that implicates the legislature and the Congress in some way, then that sends up a red flag and requires additional scrutiny and decision as to who to or how the investigation goes, and then you absolutely want to be with Assistant United States Attorney handling the case and deciding what steps to be taken.
So we would assume then in this case that the Department of Justice and the FBI decided it was okay if members of Congress in the legislative branch were the subject of your inquiry because of the location of this phone call in the
I'm not certain
House
that
gallery.
I'm not certain that in and of itself, the fact that there's this one telephone number that is a main number would be sufficient to raise the flag of, okay, we're going to get congressional conversations across this line.
Well,
and it's not across this line. It's not that at all, because remember, it's a toll records. It's a request for toll records, not conversations themselves.
Now, I'm in terms of investigating leaks of classified information, certainly that's a worrisome issue. But why did you think it was necessary to seek records for so many telephones used by so many reporters in the AP case? Obviously, many of the records under this subpoena wouldn't have relevance to the leak investigation. Did the FBI have a process for minimizing the collection of irrelevant records from the subpoena, or did all the data get uploaded into FBI databases regardless of relevance?
Well, we are adapting, let me just say, adapting special procedures to assure that the records are protected. In terms of the numbers, I'd have to leave that to the Department of Justice, and it's an investigative, it's in the midst of investigation still. I will tell you, I do believe that there was a substantial effort made to minimize the request.
Let me just close with this. In order to get a subpoena for the records of the reporters, they would have to be implicated in this leak investigation. Is it the FBI...
Did you say they would have to be implicated?
The reporters. Is it the FBI practice to consider reporters, editors, and publishers who print stories about classified government matters as criminals? And how many times since you've been the FBI director has the FBI sought reporters' work materials or communications with search warrants alleging that they are criminals?
Time of the gentlewoman has expired, but the director may answer the question.
We quite obviously don't consider that category that you listed as criminals in any way, shape, or form. Our focus is on identifying that individual who has those secrets and to whom that person has given the secrets. Part of that investigation goes to show the contacts between the person who is leaking the materials and the person publishing the materials. If you go to court on this, you have to show that this particular set of materials that were leaked went to a particular person for publication, but the focus is on the person who's doing the leaking. And the last part, I can't recall. How many
Would you
times?
get back to us on that?
Yes, ma'am.
Thank you.
The gentleman